Today's question is, can my divorce decree regarding the parent time and custody schedule be redone? Because at the time it was entered by the court, I was a vulnerable adult and unaware of what my rights or what I could do are. My mental health was suffering. I didn't even attend the hearing. The entire decree is unfair. Is there anything I can do, and if so, what? Well, there's a case in Utah that's almost precisely on point with the circumstances you describe. It's Hogge versus Hogge, 649 P. 2nd, page 51 at 54, Supreme Court of Utah, 1982. Quoting that case, it is apparent that a material circumstance relied upon in originally awarding the appellant, who was awarded custody of the children at the trial court level, of the infant twins, was the fact that the respondent was then unable, the wife, was then unable to care for the children because of emotional illness attendant to the divorce. At the hearing on the petition to modify, respondent, the wife, the mother, produced ample evidence that since the divorce she had overcome her emotional problems and had again become a capable, responsible parent. Based on this evidence, the district court specifically found that respondent's emotional stability had returned and concluded that a substantial change of circumstances has occurred since appellant, the father, was awarded custody of the minor children. In that, the respondent's, the mother's, emotional problems have been overcome. This finding, which is amply supported by the evidence, according to the court, is sufficient to justify relitigation of the question of custody. Hence, the court properly proceeded to the second step in the bifurcated process of determining whether to modify custody, a de novo consideration of all evidence bearing upon the question of the best interest of the children. Since the district court found no fault with the care of the children in his custody, appellant contends that it was neither reasonable nor necessary to transfer their custody to the respondent, and the court's order doing so would arbitrarily uproot them and engender emotional harm. It's a good argument, don't you think? Well, this is how the Supreme Court responded. Appellant's argument puts too narrow a construction on the standard for modification of custody. The court is not required to determine merely what is reasonable and necessary for the welfare of the child. Rather, it must decide what is reasonable and necessary for the best interest of the child. Now, if you see a distinction there, I don't, but anyway. That's a standard which may frequently and of necessity require a choice between good and better, whatever that means. Evidence at the hearing in this case demonstrated that during the entire time appellant had custody of the twins, they were placed in a daycare facility because appellant and his mother and stepfather, with whom he lived, all worked full-time during the day. Does that sound like punishing someone with a full-time job? But I digress. Appellant testified that the children would remain in daycare even after his forthcoming remarriage because he would continue to work full-time, and his 17-year-old fiancée intended to complete high school and also work part-time. Appellant further testified that to facilitate the twins' adjustment to his remarriage, he and his new wife did not intend to take their twins into their new home immediately, but would leave them with appellant's mother, picking them up only on weekends. Finally, although appellant's fiancée testified that she had formed an emotional bond with the twins and thought of them as her own children, she stated that she wanted to wait a long time before having any children of her own. With regard to respondent, evidence produced at the hearing demonstrated that she was a responsible, caring parent in whose custody the twins had blossomed during a 2-month visit the previous summer. Further evidence showed that she was happily remarried in a stable family environment with a husband who was sincerely affectionate toward the twins and with whom she had a baby daughter. The district court also found that respondent's new husband was steadily employed in a responsible job, I guess the appellant wasn't, and that the respondent remained at home as a full-time mother to her children. In a child custody contest, the court goes on, the extent to which each contesting parent could care for the child personally is an appropriate consideration for the court. And they cite the case of Lembach versus Cox, 639 P. 2nd, 197 in 1981. Weighing all the evidence in the instant case, we cannot say that the district court's conclusion that the best interest of the 3-year-old twins would be served by transferring their custody from appellant to respondent was so flagrantly unjust as to constitute an abuse of discretion. Now that's from the Hogge versus Hogge decision. Now, if you did not notice, Hogge versus Hogge is an old case. It was decided in 1982. Since then, the case and its holding has been distinguished by subsequent case law, including the case of Kramer versus Kramer, which the Supreme Court of Utah decided in 1987. And that too is an old case, but you get the idea. Quote, "In essence, on its facts, Hogge creates only a narrow exception to the general rule spelled out more fully in the case of Becker versus Becker, 694 Pacific Reporter 2nd, page 608, Utah Supreme Court, 1984, that ordinarily the change of circumstances prong of the Hogge test must focus only on the custodial parent. Any other approach will only promote ping-pong custody awards, precisely the evil Hogge was intended to eradicate. As Becker reiterated, the rationale is that custody placements, once made, should be as stable as possible unless the factual basis for them has completely changed. The narrow construction we place on Hogge is not an innovation or a change in our case law. Rather, it is consistent with the approach this court implicitly has taken in applying the first prong of Hogge's change of custody test. Every case that has relied on the Hogge analysis in reviewing a ruling on a petition for a change of custody has been based exclusively or primarily on an evaluation of the custodial parent's circumstances. In the usual case, the non-custodial parent's change of circumstances is relevant only to a determination of whether, under the second prong of the Hogge-Becker test, the best interest of the child warrant a shift in custody, an issue reached only after a change of custodial circumstances has been found and the custody issue has been reopened.